Um, I have a PowerPoint presentation to take everybody through what I thought was the important points in my article, and so I'll just get started with that because I think so. What I'm going to do essentially is that I'm going to look at the workings of the Foreigners Tribunal from a rule of law perspective, and for the benefit of everyone, Ashish to circulate some readings on rule of law, so that we understand what it means to evaluate something or to compare something's working in a context, in a framework of rule of law. What it simply means, I mean, to on a very basic level, is that whether the functioning of a body which is affecting people's right, which is affecting people's liberty, is that something that is approved by the law as we understand today. And now it is in that context that we are going to look at the functioning of the Foreigners Tribunal in Assam. Now, before I begin, I want everybody to just spend, about a minute just looking at the geography of Assam. Now, I'm not going to explain the geography, but you just have to observe the state borders, the district borders, and the country borders. Now, this is going to be relevant when we are trying to understand the history or the context in which the foreigners tribunals have emerged, because it cannot be divorced from the social and cultural context in which they emerge. Just Bangladesh is what parts of Bangladesh are touching which parts of Assam. Look at the other neighboring states. Look at neighboring countries, and this sort of will contextualize everything, and we will obviously look at a larger picture in the slides that are going to follow this. I'm just going to spend another 10-15 seconds on this, and then I'm going to move further, but I want you to all to observe very carefully. Okay, I'm moving forward now. When you're looking at the current legal scenario, one must understand the key events that has happened with the area, and especially the areas, the historical aspect to it, and that's relevant essentially because large part of argument that are drawn for holding a NRC in Assam is on account of the context or something that you've heard over the years. Now, if you look at 1905 and 1930, what are the major events that have happened? It was partition of province of Bengal into west and east, and then um, that was also the time when the business in Kolkata was thriving, and Kolkata, the center of activity in the eastern part of the country, but more so for the eastern part because uh, promoted, and there was a clear objective to populate the uh, Brahmaputra region and also to populate the hilly areas in Assam for cultivation of tea. Now, then in 1947 there was partition. Uh, Between 1947 and 1950, large number of people migrated from both sides of the border. So you have Urdu-speaking people migrating from India to Bangladesh, and you have Bengali-speaking people migrating from Bengal or from Bangladesh to India. Now, you may appreciate the problem or the scale of the issue is because in Bangladesh, uh, the people who moved to Bangladesh, they are referred to as Biharis because they are Urdu speaking Muslims mostly from Bihar who have come to Bangladesh. Now in 1949 and 50, the Constitution of India that was adopted, it provided for certain basic principles, which was number one, that India was going to be a secular nation where person's identity was not, I mean, religious identity was not relevant vis-a-vis the state, and the state was required to be blind to it. Then the citizenship articles essentially dealt with whether you have arrived in India, whether you have an animus to leave, either leave Pakistan and come to India, and that was really the arrival India or the presence of India that was relevant. There was complete, like I said, I mean, religion was supposed to be irrelevant. Then, and most importantly, there was a freedom of movement and to settle down. So it was possible for anyone to freely move from one part of the country and go live in another part of the country. So anybody from say Uttar Pradesh could have gone and started living in Assam, and somebody from Bengal could have started living in Assam. Somebody from Tamil Nadu could have started living in Assam, and it could be for various reasons. Somebody, somebody who got admission in a college there, or somebody who was teaching there, somebody who was posted there, retired there, and started living there. Somebody who chose to get involved in tea business, wanted to settle in Assam. So I mean, that's the kind of freedom that the constitution guaranteed, and a large number of people may have exercised that freedom to settle down in Assam. Now, in the backdrop of the communal violence that followed partition, um, there was a 1951 National Register of Citizens that was created in Assam. Now, a large number of people say that I mean that this was an incomplete exercise, because the exercise was to be completed in about 20 days, and it did not take into account that a large number of people who had left their natural or their ancestral homes and had gone out of that place. As a consequence of which they were left out of the NRC process, and by the time they came back, the NRC process was already complete. So their name had been left, because in order to save their lives on account of communal violence, they left their homes for say a couple of months or a couple of weeks or maybe a year or two, and then when they came back, the NRC was already complete. Now, in 1971, there was, I mean, Bangladesh freedom struggle. Then you all know about the creation of Bangladesh, and the linguistic persecution that was all around those timelines that we are talking about. One thing that I have not mentioned in this slide is the existence of another pandemic at that point of time, which is also relevant when we are talking about people who are migrating from one country to another or one region to another. Now, I mean, obviously, we all understand that the role that India had played in liberating Bangladesh, and because of which I mean, India has always had a soft corner for those people who are fleeing persecution from in Bangladesh. So, I mean, if you look at the geographical boundaries, before 1947, you have one undivided India, which had Bangladesh and Pakistan in its fold. After partition, it created Pakistan in two halves, east and west. And then after 1971, you had Pakistan on one side and you had Bangladesh on one side. And and obviously, I mean, if you look at the time of partition, it gave an option to a large number of people to choose whether they want to live in a secular country, say India, or they wanted to go to Pakistan, east or west. I mean, and that's the kind of option that some people still talk about in the context of CAA, that, I mean, their ancestors had decided that they liked the constitution and they liked the promises that the Indian constitution at that point of time had made of equality, of secularism, and they decided to stay back here. Now, uh, if you look at the broad timeline since 1979 to 1985, there was a protest in Assam that was going on, which resulted in Assam Accord, and the demand essentially was for deportation of all illegal foreigners who were, branded as Bangladeshis. and that resulted in signing of Assam Accord. Then we will come to the two aspects of Assam Accord. In 2004, the citizenship law was amended, which included the definition of illegal migrant and introduced certain limitations. Also provided for preparation of NRC and empowered the government to do so. It also allowed the government to create a population register. Now, between 2005 and 2010, there was an attempt, the instant of ASU, to create a subcommittee which will do the NRC exercise on a pilot basis, but on account of massive protest, it was called off. Between 2011 and 15, there was a new subcommittee that had been constituted, which came up with simplified modalities for NRC. And now, what is this? This essentially is the simplified modalities. This is the problem area. Why? Because you see, this simplified modalities are the modalities that one is required to do in order to get his or her name included in the register of citizens. That is to say that this list will determine what documents you can or you cannot show in order to be included in the list. Now, the question that I'll pose later was, you have to keep this in mind, that whether these simplified modalities law, or could they constitute law in the ideal understanding of how the legal systems must work. Now, in December 2014, there was a Supreme Court judgment that directed to detect foreigners, framed a time schedule, and by the same judgment, it also directed the High Court to set up FTs and monitor their functioning. Now, next, in December, there was first draft of NRC. There were issues with what documents can be accepted, cannot be accepted. Then there was a second draft list of NRC published in which 4 million were excluded. Then on August 31, 2018, the final list was released, in which 1.9 million people have been excluded. Now, exclusion from the register of citizens does not mean that a person is declared to be a citizen or a non-citizen. It only means that those people who have been excluded may not be at this stage proceeded again, but those people who have been excluded from the citizenship. Let me just rephrase that. All those people who have been excluded from the citizenship register stand exposed to a mandatory proceeding for determination of their citizenship. This citizenship determination is to be done by Foreigners Tribunal on a reference being made by the district magistrate. That's how the system is provided for now. And this determination of whether these 1.9 million people have been rightly excluded or wrongly excluded, this decision is distinct and separate from all the pre-NRC cases that we have seen. So at this point, please understand that there are cases of persons who have been excluded in the past. That is to say, in 2010, there was a reference made by, say, Election Commission of India to determine whether somebody is a foreigner or not. The law that applies to that person will be distinct from the law that applies to those people who have been excluded from NRC, even though those people, everybody in that sense, is a resident of Assam. But different sets of law will apply to you depending on when the reference has been made. Now, in 2019, the government had proposed the nationwide NPR, and there was a Citizenship Amendment Act excluding Muslim immigrants from certain countries from the definition of illegal immigrants. Now, this is the backdrop of how the Assam situation from 19th early 20th century has evolved and led us to 2020, and how we can probably perceive the whole Assam issue. To my mind, the Assam issue or the problems faced by people of Assam is an example of the problems that the whole of India is going to face unless we rectify the identified legal issues. And once we decide that it is a legal problem, it is something that requires rectification, the what is true for the rest of country will be true for Assam, because it's not like Assam has a separate constitution. Of course, I mean it does have a separate citizenship regime, but whether it can have a separate citizenship regime is also doubtful. I mean those matters are pending in court. But I mean there are people who argue both ways, and that's not the topic that I want to deal with today. But having said that, the rights that the Constitution guarantees in Part 3 are equally available to every citizen, whether they are from Assam or any other part of India. Now, since I have decided to contextualize, since I've decided to study the functioning of Foreigners Tribunal in the context of rule of law, I just wanted to, introduce you to certain basic concepts on rule of law, and also at the same time make it very clear that the understanding of rule of law is fluid, which means that what I understand to be a rule of law, or what I understand from the contents of rule of law, may not be what, say, Britain understands, or what Canada understands, or what Pakistan understands, or what Bangladesh understands, or what Sri Lanka understands. Or even though all of them will be claiming that they are adhering to the rule of law. So it's obviously, the content, everybody has some degree of adherence to rule of law. It's only about defining it and getting closest to the ideals. And in that sense, that is the principle that is vis-a-vis the constitution. So if you have to look at, for example, the middle column on how the rule of law has been theorized by Raz, is that laws must be prospective, open, and clear. Prospective, that I should know in advance what is going to happen to me if I don't do something in a particular way. They have to be open in the sense that they have to be known, they have to be clear, there should be no scope of ambiguity. And the reason I am going into a little bit of detail on all of this is because this will become clearer to you and relevant in the subsequent discussion that we are going to have on how the tribunals are constituted and they are applying the law. The second principle is laws are relatively stable, that they should not be changed overnight, that the principle that applies to X should also apply to Y. If it's in the reasonable proximity, it shouldn't change very often. Making of the laws is by open, stable, clear, and general rules. The independence of judiciary must be guaranteed, that the principles of natural justice must be observed, that the courts have review powers over the implementation of other principles, that courts are easily accessible, that the discretion of crime preventing agencies is not allowed to pervert the law. Now, for example, this is broadly the theme. I mean, all of these principles apply in varying degrees in varying contexts in countries. Uh, but having said that, our system has ensured that we stick closest to these definitions. So in this context, in the context of citizenship, when we are talking that law should be open, law should be prospective, law should be open, and law should be clear, what is the law that we are talking about? Is it only the procedural law that we are talking about, or is it substantive law of who can be a citizen or who is a citizen? Can you strip people of their citizenship by a law which is say retrospective, or can you devise procedural basis to strip people of their citizenship by saying that, all right, we will not take away citizenship from you, but we'll only create procedures that make it impossible for you to prove that you're a citizen. So that's doing it indirectly. Then is when we say law, does it include, like I said, I mean, we were discussing about modalities. Is simplified modality a law? If simplified modality is a law, then should that law not be coming from the legislature? Then are the guidelines that are developed by, say, Registrar General of India, or even by Supreme Court, is that law declared in advance? So will somebody who has to prove their citizenship in the year 2005, will their ancestors know in the year 1970 that I have to hold this document very dear to my life, very close to my heart, because if I don't 45, 55 years later, when my children have to prove their citizenship, they will not have the benefit of this document. And that's precisely the predicament that a large number of people are facing today. I was actually talking to a person. He told me that his great grandfather was a landlord at some point of time in the 30s, but he was murdered in the communal violence. Then they didn't have any means to live there, so they started living in a tea estate. Now once you live in a tea estate, you are essentially, everything is, the life is inside the tea estate. Now the tea estate is not coming forward to give any document, so they don't have any lease document because they were living as laborers in a quarter given by tea estate. If the tea estate doesn't come forward to give any documents, they won't have any, and they are not very educated, so there are no school records. Even if in some cases when you go to school to look for the records, it appears that, in a flood of 70s or 75, because every year there's a flood, the records have been, wiped clean. So I mean, those are the kind of situation that you deal with. So I mean, coming back to the point, the law should be declared in advance. Now, can a different yardstick be applied depending upon location? Can guidelines take away important protection that are given to citizens? Now, one argument that arises is that whether or not these people are citizens, it itself is in doubt. Therefore, why extend the benefit of Part 3 of the Constitution to them, which is only available to the citizens? Well, this sounds very interesting argument, and it's very easy for one to succumb. But in today's scenario, you see, Article 21 rights are, I mean, the whole of 14 and 19 is sort of imported into 21, and 21 is available to any person. But having said that, uh, even if the presumption is that they are not citizen, that is presumption is confined to a particular statute. The presumption is not available against the constitution. So I mean, these are all issues that are yet to be tackled. Probably they will be highlighted and argued in some case. Now then the last question is, which are the agencies that are entrusted to implement this law? Now this is important because the powers of the agencies, the objective of the agencies, the way in which the agencies are trained to perform certain role, those define how they are going to apply those powers. For example, um, both Border Security Force and Election Commission are making references to Foreigners Tribunal. Now, Border Security Force is concerned with, say, security of the borders of the country, but Election Commission is concerned with non-citizen not voting in elections. Now if you look at their functions, their objective, their methodology, their approach will all change, because Election Commission will not have the power to investigate, whereas Border Security Force may have some police powers and we can investigate. So the kind and the quality of reference that they make to the Foreign Tribunal is bound to differ, and we'll come to this a little later. So in terms of, purely in terms of understanding how the law operates, I mean, first of all is the constitution, then there will be act, then there will be rules that are made under those acts, and then there will be executive orders or notifications by which the government or the appropriate agency under the which is permitted by the act will exercise certain powers. Now I want you all to consider this hierarchy and make a special note of it, because as I will show in the later part, foreigners tribunals does not really follow this, and there are good historical reasons for it. We'll come to it. Now foreigners tribunal is I mean, the function is obviously to determine whether a person is or is not a foreigner. So what is happening is Foreigners Act. Now that Foreigners Act only defines, who's a foreigner, who's not a foreigner, and gives very broad powers, but it does not do anything further. It does not allow creation of a tribunal specifically. It does not allow any sort of guidance on who the tribunals are going to be presided by. It's a very high level act. In fact, the first Foreigners Act was enacted in the year 1864, which was a couple of years after the British Crown took over from East India Company. And since then, there were two or three avatars of the Foreigners Act. The objective of Foreigners Act is not really to identify whether a person is a citizen or not. That's not the exercise that it really attempts to do. Um, and for that matter, the exercise of verification of a citizenship is also a distinct exercise. It's like, very loosely speaking, to identify whether you belong to a particular area, or I will say, all right, show me some documents that you have a residence here. I will see one document and I'll say, all right, this seems okay, you can go now. Now that's the kind of exercise that's only a verification exercise, and I am not getting into whether the document is issued properly, whether who issued the document, what is the underlying document to get this document. That's not the exercise that I am going to do, because it's only a verification exercise. You show me something that you're a resident in area and I'm fine. I mean, you must belong here. But if I have to do a different kind of exercise, which is to determine whether or not you are residing in this area for good reasons or for a particular area, I'll have to go a little deeper than that. And that may be an exercise which may be required to be done by a separate law altogether. Now, if you look at the Foreigners Act of 1946, the Foreigners Act 1946 came in the backdrop of Second World War, and pretty much identical legislation exists for Myanmar and I'm sure certain other neighboring countries which were under the British Crown. The objective is that the government of those time did not want a foreigner to be loitering around in the country. So they said, all right, identify this person is a foreigner, not a foreigner. All right, he doesn't have anything. Why? Because the burden of proof is on him. So you show whether you belong here. You don't have anything to show that you belong here. Okay, summarily put in detention camp, maybe deported. But that's the objective of the Foreigners Act, and it started from 1864 when they were trying to build their dominance in India, and then there was two or three other legislations preceding it, broadly on the same lines. Now that's the law, 1946 legislation, that is being invoked today to do the exercise of citizenship verification, an exercise that the act is not meant to do. Now I just want you to also understand that in the year 1947-48 there was also the Industrial Disputes Act. Now, Industrial Disputes Act, and there are many other legislation. I've just picked up Industrial Dispute Act for my benefit. That Industrial Disputes Act provided for a tribunal. Subsequent amendments came in the 70s, which also altered the structure of the tribunal. But the tribunalization was happening even in late 40s, and it was known to the government. And in the Industrial Dispute Act, there is a provision of appointing a person capable of manning a tribunal. But the Foreigners Act does not itself provide for it. It is provided delegated legislation by an order made under the act. So now who are the people who can make references? It is the border police who can make a reference, election commission who can make a reference, and since the power is delegable, it can be delegated to any agency. I mean, right now it's really delegated to the district magistrate. Now in the post NRC situation, there will be appeal or references that will be made by the district collector. Then now if I gave the example of Industrial Disputes Tribunal, or the labor courts as they are popularly called, what are these Foreigners Tribunals? At the end of the day, Foreigners Tribunal constituted under the Foreigners Tribunal Order of 1964, they are essentially tribunals. They have all the trappings of the court, and they have to justify their method, their invocation, their constitution, their working strictly in accordance with the constitution. Now why what we are going to discuss now is focusing only on foreigners tribunal is one, their establishment, how they are established, two, what is the procedural law that they apply, and we will comment briefly on the nature of substantive law that they apply. Now, when you are looking at the foreigners tribunal and looking at what we are going to discuss, please do remember that foreigners tribunal so far has decided on a large number of cases. I mean, about over a lakh cases, where 60% have been decided ex parte, and in future it has to decide 19 lakh 1.9 million more cases, and it is in that context that you should view the functioning of foreigners tribunal. Now, first, let's look at the establishment. Now, the left-hand side column shows you the requirements under Indian law. Now, I have not specified which requirement flows from which law, which judgment, but I'm sure, I mean, you would have found some from the article. And also, if you just do Google on creation of tribunal and in relation to the Indian Constitution, you will find some important judgments on this. Now, first requirement is that the tribunal must be created by law. Has it been created by law? Well, you look at 1948 Industrial Tribunal created by law, 1964 Foreigners Order. So I don't know how the adjudication was really happening between 50 to 1964, because there was no tribunal. So I'm sure there must have been some sort of a mechanism that was functioning, and I think it has found observation in one or two judgments also, but it was not, there was no formal tribunal. The formal tribunal was notified in 1964. Now, is the appointment secured or permanent? Well, it is a contractual appointment, because the members of the foreigners tribunal are appointed initially for 1 year, and then their contract is renewed in the subsequent years. Is the appointment after a written competitive exam? The answer is no. You see, written competitive exam may not be really a requirement under the constitution, but there are judgments of the Supreme Court that say that that having an open examination or an open system of participation where suitability merit of the candidate can be judged is a sine qua non. And uh, it is in that context that, if judicial officers are being recruited by judicial for example, by Delhi Judicial Services, or for ADJ there is higher judicial services, why can't you have a examination for recruitment of the officers or the judges of the foreigners tribunal? Does the appointment process respect diversity? Well, in the notification that I'll just discuss, there is no discussion on whether rules of reservation will be followed, whether there will be women member, where there will be SC ST, whether there will be any other sort of respect for any kind of diversity. Are the qualifications prescribed by law or by rules? Well, it is provided very vaguely that it should be a person in the having judicial experience, but that's also not provided by law. It is provided by an order. So as far as I am concerned, I am saying that the qualification has not been prescribed, because a vague description of judicial experience means nothing. Whether the appointees get judicial training, the answer is no, because in the present scenario, the foreigners tribunal members who've been recruited, they got a 4-day orientation program, and that was really the training for them. Now, this must be contrasted with other situations. For example, in the UK, if there is a judicial studies board that mandates that there must be a training for members of the tribunal. Now, why is this important? This is important because even when you are having advocates to advocates are people who have been very regular in presenting one side of the case. I mean, they may be able to assess the weakness and strength, but that's essentially about it. I mean, they are not people who are trained in appreciation of evidence, trained in appreciation of receiving conflicting evidence. And that's why training plays a very important role. Now, do the appointees have a decisional autonomy? Now, what is a decisional autonomy? Decisional autonomy is your power to take independent decisions. So when we are talking about independence of the judge or independence of the tribunal, independence of judiciary, what are the concepts, what are the precepts that we are talking about? We are talking about two aspects of it. One is that there has to be, as a system, they should be independent, and two, the judge, the person concerned who has to take the decision, he or she should be able to take independent decisions. Now, in the context of foreigners tribunal, where you are on contract for 1 year and that contract is going to be extended depending on how you perform, there is no decisional autonomy, because your performance is eventually measured by people who are looking at you, and the only way in which judges performance could be reviewed is by an appellate process. I mean, obviously, if there is allegation of corruption or any such thing, I mean, there's a separate mechanism for that, and even there are departmental inquiries even against the judges. Those departmental inquiries are actually in the nature of protection that is given to them. That is, look, that is to say that if you are not performing well, or if you are misbehaving, or you are not acting like a judge, then there will be proceedings against you where you will be given all your rights will be affected. You will be given an opportunity to present your case, and then only an adverse order will be passed against you. But that's not the kind of protection that the members of the foreigners tribunal have. I mean, of course, the state government has come up with an approach of, giving show cause notices to members of foreigners tribunal where before terminating their services. But having said that, that's not the kind of protection that a judge or a magistrate gets, and it doesn't really contribute to the decisional autonomy of the person. Now, do the appointees report to any authority? Well, in a manner of speaking, they do report, because their performance is audited. I mean, I would use the word audited consciously, because the Supreme Court directed the Guwahati High Court to take charge, and it directed for recruitment and to oversee how they are functioning. But that has sort of been understood that the Guwahati High Court has to see how every tribunal is passing order. As a consequence of which, the tribunal, if you ask for time, they will say no, we won't give you time. I mean, they will not say it, but the background is that, look, somebody is looking at how I am doing. So if I give you 2 or 3 or 4 adjournments because your documents have been washed off, or you want to get more time to get a copy made, then because my performance is being reviewed by some other person, they will view that I am very lenient, and I don't want to look like I'm a lenient person, and therefore I will decide in a particular way. And this virtually means that there is actually a structure where they are reporting to an authority. It may not be directly, but their work is being reported. um, can the appointees be called independent? Well, if you are not able to take decisions on the basis of facts on files, and you're always conscious of other people viewing your work, other people reviewing your work, apart from in the appellate process, and your job really being dependent on that, then certainly it can't be said that the appointees are independent. Can the selection criteria be easily changed? Well, it has been. And I'll just come to that. Are they accountable through appellate process? Well, the answer is no, and there is virtually no appeal. And this issue about not having an appeal from a determination came up recently also. I mean, you may have heard or maybe read some pieces on it. Prashant Bhushan's conviction by the Supreme Court, uh, he did not have any remedy of any appeal process. I mean, so whatever his grievances were, there was no further remedy for him to argue those points or to agitate those points. So his argument was then that, because there is no further appeal that is possible, convert my review petition into an appeal, and that's how you should really review the appeal. Look at my review petition. Now, when it comes to advertisements, um, this advertisement of 10th June 2019 of Guwahati High Court. Now, I'm just going to go one by one over each of the requirements, which is this notification said, I'm reading, applications are called from experienced advocate, retired judicial officers of Assam Judicial Services, retired civil services, in an online mode for preparing the panel of 221 candidates for appointment as members of Foreigners Tribunal on contractual basis. And the number of vacancies may increase or decrease in future. Well, the first requirement of citizen of India. Well, I have a problem with this because you see, and there is no examination. So, citizen of India, what if your case has been already? You're a lawyer, you want to apply for this, but your case has already been referred by, say, Border Security Force or by Election Commission that that you are not a citizen of India, and then the presumption merely they because they made a reference and a notice is issued to you, the presumption against you has triggered. So I mean there is a problem here. Then you are essentially excluding certain set of people from this. I mean I am not for a moment saying that a non-citizen of India should be allowed to preside over, but there has to be some caution that is to be exercised in administration of this clause. Now the second is retired judicial officers of Assam Judicial Services. Well, I think this is a fine criteria. Second is retired civil servant not below the rank of secretary or additional secretary having judicial experience. Now it doesn't say having judicial, it says having judicial experience, but what kind of judicial experience? If somebody has been posted, say, performing quasi judicial function for 3 months, 4 months in his entire civil services career, will that be counted? Or somebody performed judicial experience maybe 25 years ago, is that good enough? How is it going to work? And I mean, how can you allow retired civil service servants who do not necessarily have any training in adjudication as members of Foreigners Tribunal merely because there is a claim that they have judicial experience? Second, advocates not below the age of 35 years with at least 7 years of practice. Now, we must pause here for a moment for two reasons. When it says at age of 35 years with 7 years of practice, in the previous recruitment, the experience was 10 years and the age was 45. This essentially means that the criteria for it can be changed because it only said judicial experience and nothing more. Now this 35 years or 7 years of practice is the same criteria that has been mentioned in the constitution for recruitment of sessions judge. So if sessions or a district judge, because higher judicial services have virtually the same requirement, not below the age of 35 and with 7 years of practice. But every advocate who qualifies the HJS is then required to write an exam. I mean, maybe 2-tier exam followed by possibly by an interview, and then there is a training, brief training, and then only they are allowed to preside as judges. But all of that is absent here. Now it says candidates will have to have fair knowledge of official language and Assam its historical background giving rise to foreigners issues. I mean, I have not understood what is the purpose and what are they, what is one trying to achieve by doing this, and what is, and there is no written examination. This selection process has to be done by way of an interview. Now, I mean, my assessment. Allowing this sort of vague criteria to pass through only through interviews is not acceptable. It says further that the initial appointment shall be for 1 year, which may be extended from time to time on need basis. Now, if you know that there are 1.9 lakh cases that are to be adjudicated, and it is in that backdrop that you are really appointing people in 2019, then why doesn't the state consider creating a separate, distinct services for judicial officers who are trained sufficiently or who are qualified to do this kind of work? Why have this ad hoc approach to it? Now, on the procedure that is to be followed by the tribunals, requirement under Indian law, again I have followed the same table format. Requirement under Indian law, an ideal rule of law requirement, and whether complied by Foreigners Tribunal. For a tribunal having power to affect personal liberty, the procedure should be provided by statute. It is not provided by statute but by an executive order. That executive order is not even required to be placed before Parliament. If you compare this with other statutes, I mean, if you compare it with the Consumer Protection Act, or you compare it with tax tribunals, or you compare it with the NCLT rules, there are rules everywhere. But those rules are some, they are regulated by legislation in some manner. I mean, there is absolutely no regulation that is happening here. The criteria for doubting anyone's citizenship and thus making a reference to foreigners tribunal, there's virtually no criteria that is available. So like I said, the election commission making a reference on some basis, and border security force making a reference on another basis, the level of scrutiny, the level of doubt, the level of understanding of why somebody could or could not be a foreigner could vary. So there is no minimum threshold that is required to be crossed before a reference could be made. Now, one could argue that it really talks about subjective satisfaction, and it's very hard to provide some kind of a basic criteria. Well, I have my reservations to such an argument, for the reason that if you are triggering a reverse burden of proof, you must have something. I mean, even when you apply, for example, reverse burden that is available, say in other in customs, for example, you have reverse burden in case of gold smuggling. So there are certain ingredients that are to be required to be fulfilled before reverse burden is going to be triggered. I mean, here, well, that requirement is couched in the word of subjective satisfaction to be arrived by anybody and everybody, on which there is no regulation. Then is show cause notice issued? Yes, a show cause notice is issued, but so far, there have been 60% cases have been decided ex parte. Is there a requirement for service of notice on the person? There is a long procedure provided for, but various case laws have again and again demonstrated that they are not followed. What about burden of proof? Well, burden of proof is on the person who's alleged to be a foreigner, and this is a statutory requirement which is carried forward from the previous legislations. This legislation is a pre-constitutional legislation, and therefore, I mean, it has to be really tested on the anvil of the constitution in the current scenario. Does the Foreigners Tribunal order provide for provision of legal aid? Well, it's not guaranteed. Now people have woken up, some states, even states are coming forward and saying we will provide legal aid, but I'm not sure what kind of legal aid could be provided, because essentially everything is to be decided on the basis of documents. Those documents, only the person who is alleged to be a foreigner is a person who is capable of producing it. Where will that person go to get those documents? How will he get it? These are all issues, very tricky issues. Therefore, legal aid regime is bound to be insufficient unless there are other attendant changes in the regime. What about quality of lawyers and freedom of lawyers? Well, it is reported that lawyers are pressurized by some local bodies. But having said that, looking at simply by the quality of arguments, the quality of evidence, the quality of material that is placed and discussed by the tribunals, the quality of lawyering is also not very effective, and I would say it needs to be improved alongside the functioning of the tribunals. Now, what about principles of natural justice? I mean, for example, cross-examination routinely denied. Why? Because the discretion is couched in a wording where they think that this time is being sought only because you want to buy some time and you don't want to cooperate in adjudication. They will deny. Natural justice, if there's a delay in obtaining document, what do you do? Well, we have already seen the 60% orders have been passed ex parte, whether it is on whether and also in a large number of cases the tribunals and the high court also has taken the view that since the burden is on of proof is on you have to make effort to get the document. If there's delay in obtaining documents, or the person who has to prove the document can't come forward, well, too bad. Now, the nature of proceedings, the tribunal are held to be quasi judicial and not performing functions of a court, and hence host of protection that are available in regular proceedings are not available here. For instance, res judicata does not apply, which means that the same person can be proceeded against in one district and he comes out successfully, proves himself to be a citizen, but in another district, he can be proceeded again. So I mean, very anomalous situations we can see. In fact, one member of the family, for instance, is an Indian citizen, the brother is not an Indian citizen, even though the lineage is really the same. Why? Because one person missed one document and things like that. Is the appeal provided? There is no appeal. There is only a writ that will lie, and proceedings after proceedings. Guwahati High Court has held that in writ jurisdiction they are not going to look at the facts. They are only going to look at the decision-making process, and that's about it. So whenever they found that there is a faulty decision-making process, that some relevant document should have been considered, has not been considered by the Foreigners Tribunal, they will remand the matter to the Foreigners Tribunal and ask the Foreigners Tribunal to be to consider those documents and to decide the matter. So and now what is happening is that so you have one tribunal which is functioning like this, and that tribunal decides a fact. The High Court says that look, the tribunal has determined this is a fact. You may challenge it, but that challenge we are not going to accept because we are sitting in judicial review in 226. We can't do that. Now you lose the case in High Court. Now from the High Court you're sent to Supreme Court. Supreme Court will say, look, finding of fact given by tribunal is binding. High Court is correct. It can't get into these issues in 226. Therefore, sorry, but you will have to go and stay in detention center. So that's really the kind of adjudication. So you have really this horrific method being followed for determination, and then that has a seal of approval because the appellate process is very limited. Ideally, in a case like this, I mean, if I want to recover 1,000 rupees from you, I will have to file a civil suit, go through the entire process. There will be chief, there will be cross, there will be all sorts of arguments, and then finally, if I am held liable to pay 1,000 rupees to you, then I will have full right of appeal to a court. I mean, there will be a first appeal that can be argued, where there will be a challenge to the finding of fact and law. But so a civil system which is available look at rupees 1,000 as debt is not available to a person alleged to be a foreigner. So as a consequence, you have police officers, you have army officers, you have people who are decorated the President's Medal as being declared as foreigners. Why? Because the process of reference and the process of decision making for the tribunal is absolutely inadequate, and the High Court doesn't really do anything more than remanding the matter to tribunal, and therefore the entire process will have to be now done by the tribunal afresh. I mean, of course, it's a discretion before the High Court whether to remand or not to remand, but in some cases, I think the High Court should not remand. Now, last point in this slide is about open access to court. This is something that journalists have complained very often. Most of these tribunals are functioning in very small rooms, whereas there's really no space to stand or for other people to observe. It is guarded, so if somebody who's not a party, who's not a lawyer in that court, wants to go in, they will not be allowed and they will be asked to stay outside. So you don't know what kind of proceedings are happening inside. So if there are allegations of bias or the allegations of not hearing or allegations of assuming the role of prosecutor, those sorts of arguments of conduct of parties cannot be spoken outside because it's really in the nature of a secret proceeding. Are the reasons given? Well, you see, the reference is given to give an opinion on the matter. But because there is, so you give, obviously you can write 10 pages, 15 pages, you can write 70 pages for that matter. But there has to be a method in which you have to deal with evidence, you have to deal with arguments, you have to appreciate what is admissible, you have to appreciate what is the burden of proof, how that is to apply. Now, all of those things are part of training of a judicial mind. So when you are not recruiting people with judicial mind, you are not training lawyers to develop that kind of judicial mind, you are not going to get reasons that qualify as reasons in law. Now, the proceedings are time bound. Well, the proceedings are time bound, and given that the renewal of contract depends on performance, there is a certain degree of urgency in, concluding the decision in time bound manner, because then when your report card goes for your renewal of contract, it goes that, so and so a person has decided so many cases. Now that it goes with a breakdown of not only of how many cases, but also with a breakdown of how many cases have you decided which side, for or against, or declared foreigner, not declared foreigner. um, and somebody was I mean, a person whom I had met from Assam was telling me that the language that is used in the official quarters also there is kitna wicket gira diya. So that's how one is looking at it. Now, is there a power to devise its own procedure? All the 300 tribunals have their own power, and those procedures are then applied by people who are not really trained to be judges. Is there a power to extend scope? Well, what happens is, for example, if you have not been you have not been able to prove that you are a citizen of India, then as a consequence you may have failed, but the reference will be extended. All right, what about his family? Who are his brothers? Who are his sisters? Why don't also draw proceedings against those people? So those kind of things are also happening very frequently. Now this slide is very crucial because it shows the shift, and 2014 to 19, umpteen number of orders passed that direct that, all right, draw up NRC, do this exercise, these are the documents that you will accept, this is how you will do, this is the time frame, this sort of objections entertain, this sort of objections not entertain. You appointed a coordinator virtually. I mean, you coordinator is reporting to you, coordinator is arguing in court. So these are the kind of things that the Supreme Court is virtually overseeing the entire process very personally. And whereas all of these procedures should have been provided for by the legislature. Now, in 2019, in dealing with one of the matters which had come up by way of special leave petition, the court said that High Court has a limited judicial review, but some of the errors or flaws in judgment of foreigners tribunals can be corrected by limited judicial review. But it says that there is no necessity for providing appeal, because it cannot provide appeal because it would entrench in a legislative field. So all this while, from 2014 to 2019, the Supreme Court has virtually entrenched on the legislative field, but when asked to provide a substantive appeal, the Supreme Court is saying that, look, I mean, it would entrench in the legislative field. So what happens is that the judges change, the approach changes, but I mean, you live with the orders that have been passed and that have been implemented. So now, when it comes to substantive law that applied by the Foreigners Tribunal, like I said earlier, also distinction between what are the things acceptable in a pre-NRC situation, that is to say, somebody who made somebody who subject matter of a reference made in 2005 versus somebody who will be a subject matter of reference once the process starts. Is the law, is that a law? First question. Second is that law prospective, open and clear? It has changed frequently and time to time, in the sense that, at some point of time, whether certificate of Gaon Bhuda is accepted or not accepted. Now, well, you start with a certain point, you end up on another different point. Now, how do you deal with women who have migrated from one village to another? So now these are the situations which have not been contemplated, should have been contemplated when the law was made initially, or the so-called simplified modalities were evolved. At that point of time, all of this should have been considered and then floated, rather than changing them on the go. I wouldn't say that the law is therefore stable. There is no law that is enacted by the parliament. There is operating procedures. Now, why I would say law enacted by parliament is important is because citizenship is governed by parliament. It's a law enacted by parliament. The manner of taking or proving the citizenship is governed by certain abstract sort of rules on which parliament has no control. Laws should be applied uniformly. Well, they are not, because as I just said, there are two categories, and within the categories there are subcategories of how it's to be applied. There are grounds of biases, there are reported biases. In fact, one of the members of the Foreigners Tribunal his services were terminated recently because he made a remark which was regarded as unbecoming of a member of a foreigner tribunal, because he said that the money that he was donating to the Assam government should be used for charity but should not be used for a certain sect, a certain group of people, denoting a sect. Provisions of law is the same for the whole country. Well, different laws apply. Like I said, different laws applies in Assam and the rest of the country. But this, if so, this is the problem with the Assam situation. And if we don't, like I said, if we don't try and rectify and appreciate the problem in Assam situation, we could face a problem where this whole thing is then implemented in the country. Law should take into account inequalities. It doesn't really to say so. Now, I would, in my conclusion, I would simply agree with the amnesty report, which is that Assam tribunals are designed to exclude, and I've identified in a legal framework on what are the problems with the process of adjudication, and I have really looked at it from a framework, from a legal, absolutely legal point of view. Now, before I close my presentation, there's one thing that I wanted to show all of you, is the 1950 Immigrants Expulsion from Assam Act. It's really a very short act, which says which provides for power to order expulsion of certain immigrants. It says if the central government is of the opinion that any person or class of persons having been ordinarily resident in any place outside in India has or have, whether before or after the commencement, and the stay of such person in Assam is detrimental to the interest of the general public of India or of any section thereof, or of any scheduled tribe in Assam, so and so, central government may by order direct that such person or class of person to remove himself or themselves from India or Assam within such time, and give further directions. Provided that nothing in this section shall apply to any person who, on account of civil disturbances or the fear of such disturbances in any area now forming part of Pakistan, has been displaced from or has left his place of residence in such area, and who has subsequently been residing in Assam. So now you see the act is of 1950. It has certain built-in checks and balances. That is, that you were ordinarily resident outside India, that your stay in India is problematic because it is detrimental to the interest of general public, and that you have not migrated out of fear. Now this is very important because I mean, whatever the truth in statistics or data may be, large number of people who may have migrated from Assam, and both Hindus and Muslims would may have migrated on account of civil disturbances in 1950, or on account of linguistic religious persecution that happened in the 70s, in the 60s and the 70s. So I mean, the reason why I wanted to show to you is that there is a law that takes into account on all of this, and then there is a Foreigners Act which virtually has nothing, and it's the Foreigners Act which is being discussed. Now in my presentation I have not discussed um, uh, the IMDT, or the illegal migrants determinant tribunal of 1983. Now that's the piece of law that was struck down by the Supreme Court in Sarabnanda Sonwal first. The reason essentially was that the tribunals have failed in performing their duties, in the sense that they were very slow, and that so far only so many people have been identified as foreigners. And the reason, and it was argued and probably accepted also, that the reason for their failure is that they are extending due process to those people. They are not allowing reverse burden of proof, which they should have, and it is on those accounts that the act was struck down. I mean, to my mind, that was at least an act that had that may not have been the best piece of legislation, but that had some semblance of due process guarantees, which must be there in some sort of tribunal, and which are absolutely absent today, leading to chaos. So with this statement, I would like Mohsin to take over, and we can now probably move over to discussions.
Excellent. Thank you so much, Talha. That was a really comprehensive presentation, and a very sharp presentation in terms of the critique and the substance. So what we'll do, we have a fair bit of time, and I think we should take advantage of it. And I'm happy to open it up for comments. There are many people here, even apart from our students. So it'd be lovely to hear from everybody and have a conversation. So please feel free to raise questions, doubts. If you want any aspect which you think Talha should further elaborate on or clarify, that would also be wonderful. And of course, comments would also be welcome. So anybody who wants to just speak up, just you may just raise your hand and I will invite you to speak. Okay, so while we
I,
wait for people to
I just
ask,
wanted
Ashit,
to
did you?
ask something which Talha
Yeah,
mentioned at
you
the
can
very
start
beginning.
off.
Something about the pandemic in the around the 50s. I was quite interested in what it led to exactly, and because I've sort of heard of it before. If you could please talk about that a little.
So if you just look at if you do a little bit of search on pandemic in between the 60s to early 70s, there was a cholera pandemic at that point of time, which was also something that a lot of migrants from Bangladesh, I mean Bangladesh was affected, and so that may have been a reason for why people moved from one country or one porous border to another country. The reason why I pointed it out is because recently in our lives we have seen what pandemic can do to people. I mean, you're leaving, going, walking miles from one place to another, merely because you want to, you don't have anything to feed yourself, or you take care of your family, or you just want to get out of there because that's the situation. So that example was to contextualize that we don't know. I mean, we are talking about persecution, and we have a cutoff date of 24th March of 1971, and the motivations for people moving out from Bangladesh to India could be many. I mean, it could be persecution. It could also be maybe trying to just get out of there from in that pandemic situation. So just do a little bit of search on in this point, and it'll give you a picture.
Thank you.
Um, so while we wait for more people to ask questions, Talha, I had obviously a number of thoughts and questions. Um, Let me start with more of a legal question. So this whole business of limited judicial review, um, or maybe let me, because there are no questions, let me just ask two questions together. The first is, I think your presentation, or maybe I would also ask for a clarification. Your presentation, I think, substantially makes it clear that the foreigners tribunals neither fit what you call the ideal of rule of law, so some basic principles of the conception of justice and law that ordinarily we believe in, and also the manifestation of those abstract principles in our own domestic jurisprudence, say, for example, around tribunals, which, as we know, is a highly regarded, well entrenched area of law and well developed area of law in India. From your description, it is also very clear, an assessment I agree with, that foreigners tribunals essentially appear to be executive entities created through subordinate legislation, while offering some sort of like a facade of a court or a tribunal. Though there was one sentence in your presentation when you said, obviously, FTs are courts. And I guess you're holding them accountable to a certain standard of courts and then realizing that they are not courts. But I think another way to read your presentation is that, well, they're not really courts. There's a facade of being a court, but essentially it is an executive body with quasi-judicial functions, which is, that definitely can be granted. So if that is the right interpretation of your presentation, then my curiosity is more historical, which is, how did it happen that despite having such a well-developed area of tribunal law, we ended up in a position where somehow it has become a commonly held understanding that FTs are courts, or FTs are actually tribunals just because they are called tribunals. Is that a story which starts with Sonowal and then over a period of time, other court decisions have assumed that to be true? Just as a footnote, the whole debate around res judicata, for example, is peculiar because there were many people very critical of foreigners tribunals who demanded res judicata should be applicable, which obviously assumed that FTs are courts. So how did, my question is, how did that common sense started to emerge, which seems to me has become quite perhaps a problem now. The second related question was, or maybe if you could answer this, and then I'll ask the second question. Maybe others will have more questions later.
Okay, so I'm just getting to the case. There is a judgment of Hans Muller of Nuremberg versus Superintendent Presidency Jail. It's 1955 1 SCR 1284. It's there in the footnote number 63 in my presentation, and the reason why I'm making a specific reference to it is because the nature of the functioning is was discussed in this case, and the Attorney General at that point of time had sort of conceded that yes, well, there are problems because after coming into force of the Constitution, some of these provisions cannot work. Now after this there have been some amendments. So historically looking at the functioning of the tribunal, like I said, my understanding is that in 1946, when the Foreigners Tribunal Act came in, there was
Foreigners Act.
Foreigners Act of 1946. It was immediately preceded by an ordinance, and there was a previous act of 1920, and there was and the first legislation was 1864. The objective of these legislations was nothing to do with the citizenship verification. It was essentially to have a mechanism to identify who are foreigners, or just to empower somebody to who's a foreigner and remove them, so that they're not able to disturb peace or otherwise sabotage the country. I mean, it was in the 1945-46 country, and if you look at the involvement of the eastern part of the country in the Second World War, I mean, you should be able to draw some understanding of what may have been the motivation really. The second thing is that the distinction between administrative powers and the judicial powers. So to say, the initial view was administrative function doesn't require natural justice to be followed. Then that law changed. That I think initially it was essentially seen as an administrative function and not really a judicial function. That may have been the case, and therefore the law that was applicable to the rest of the rest of the country in other legislations, like for example, you have labor industrial tribunals, or the labor courts as they are called, were not made applicable specifically to the Foreigners Act. I mean, they were not devised in a way to deal with this situation, that they will be actually adjudicating on rights of someone, which will lead to statelessness or will lead to deprivation of liberty. So I think it is for that reason that the Foreigners Act itself not provide for it. The tribunals were provided, and it was the tribunal itself. The way relevant rule is worded is that so long as there is sufficient show cause notice, sufficient opportunity has been given, that's okay. Nothing more really needs to be given. That's I would say that the transition from administrative to judicial to entrenchment of judicial powers in tribunal is a recent phenomenon. It has really happened after the 80s. I mean, if you look at L. Chandra Kumar and the subsequent judgments after that, 323A, 323B, these are all subsequent events. Before and before this, there was already a Foreigners Tribunal and the Foreigners Act, and so maybe the government perception was that this is essentially an administrative power being exercised, for which we will appoint someone, because it's something that is not even meant for citizen, and it's not going to affect anybody individual, so we will deal with it. And anyway, at that point of time, the law was that the rights of non-citizens were very limited. It's only recently then when we have started to look at the larger meaning of right to life, or a role of a person, or evolve the jurisprudence of dignity, that we are saying that, look, even though they are non-citizens, but they are not any less human beings, and they have equal rights. So in it, but the jurisprudence or developed by the Supreme Court has gone further up, but the tribunals, or the Foreigners Act, has not been able to catch up with that change. And it's a pre-constitution legislation, and in that sense, it does not enjoy the same level of safeguard in terms of challenge, as the Supreme Court said in Navtej Johar, that we will, in case if it's a pre-constitutional legislation, then the presumption of constitutionality does not attach to it. So I mean, that's something that will make it more vulnerable. And as far as the manifestations of ideals are concerned, I would say that um, you see, if you look at labor law, industrial law, if you look at the tax law, if you look at NCLT, you look at consumer, these are all places where money has been involved. It's catering to the rich, I would say, in a way. So the law, in a way, it shows that the march or has been towards catering to all the legislation that are going to affect the moneyed class. I mean, in a labor legislation, it's essentially fight between those who have the money and those who are trying to get more money from them. And NCLT or consumer or other sort of that have the tribunal system, where all of the protection, all the guarantee that we talked about are already existing. And today, in my analysis, I am not doing anything more than simply applying those principles and re-importing it here. I am not saying that this is a new theory or this is how you have to do it. I'm simply saying, look, if you can provide for a judicial experience, and you can mandate in law that this can only be held by a person who is a judge or capable of being a judge of the high court or of a district court, why can't you have the same thing for foreigners tribunal? That's the argument in short.
Right.
So
sorry, I didn't mean to interrupt you, but I just wanted to agree.
So I'm looking for your second question.
No, I have on that point. I had a question, but Devanshi and Arushi also have questions. So let's take those two questions quickly, and then I will come in later if there's some time with my follow-ups based on that. So Devanshi, you want to go first?
Yeah. Can you hear me?
Yes.
Firstly, thank you, Professor, for your presentation. It was really insightful. So my question is on the basis of res judicata. Aside from the fact that maybe in this process of ignoring res judicata, then people would be in this complete loophole of coming back to the court, and they wouldn't have this piece of like living properly. But aside from that, isn't this a very impractical approach for the tribunals as well? Because there's a lot of cost, there's a lot of time, and there's a lot of resources that will be put again and again into the same or into a similar matter with the same person, and therefore the application of res judicata would just be impractical. The ignorance of res judicata would be impractical for these tribunals. So why would they want to ignore it?
Should we take Arushi's question as well, and then Talha can answer both of them together? Yeah, Arushi.
Hello, am I audible?
Yeah.
Sorry, I'm echoing. I'll just thank you for your presentation. My question was about the renewal process, the contractual appointments. Are the conditions just purely the specific quota of convictions, or do they consider maybe how judges have analyzed contradicting evidence or anything else? Because it sounds like the only means of streamlining the judges appointed, because the criterion, as you mentioned, for appointment is not specific or relevant enough. So do they consider anything else when they're renewing the contracts? And also this seems like because from according to your reading, the renewal process is decided by the government, the central or the state government. So is this significant power of the executive over the judicial function common for specific tribunals, like you mentioned the industrial tribunal, or is this for these sort of tribunals, is this common, or is this just for the foreign tribunals?
Yeah, Talha, you want to go ahead?
Yes. So on Devanshi's question on res judicata, you see, it is you're absolutely right that it is, in addition to being against the public policy angle qua the applicant or the person concerned, it also is against public policy qua the system. So I mean, from a systems point of view also, it is a duplication of the effort. um, it will obviously take more time. It will also consume more resources. So uh, while not being sound in law, it is also not sound in policy. I mean, I totally agree with your observation there. And in fact, um, you see, the logic of the judgment is also not very well reasoned, because there are various aspects of the whole process which have not been considered. So unless you consider the whole aspect, starting from the reference to the evidentiary aspects, you can't really come to an outcome that, whether this is res judicata or not res judicata. And in any event, I mean, it essentially boils down to power of making reference, and the starting point itself, like I said, the starting point itself is a problem, because anybody can make a reference. So initially the power of making reference is only with central government, because the law is clear, central government can seek an opinion from the tribunal. But that power has been delegated but to state government, delegated to authorities, delegated to everybody. So I mean, tomorrow it could be delegated to, say, a watchman. I mean, I'm just giving an example, maybe an extreme example, but the fact of the matter is that in administrative law, there must be some inherent limitations on to whom you can delegate that power. So initially, if the power was to be exercised by the central government, and within the central government it was to be exercised by a secretary, you understand that there will be a certain level of competence or understanding that a secretary sitting in central government in Delhi will have, whether or not to make a reference. But I am not sure whether the same level of competence or sensitivity is something that a station house officer of a police station in Assam will have. So, but nevertheless, the power still has been delegated to him. So, I mean, that's obviously a problem. And on Arushi's question on the renewal process, you see, the renewal process itself is not very transparent. So what we know, what at least, I mean, I know, and that's the limitation that I had pointed out. My understanding of the whole process is based on what is reported. I would, and I understand that some of those foreigners tribunal members whose contract had not been renewed, that even gone to the High Court saying, look, I mean, we had done the best, but our contracts had not been renewed. So to which the High Court had dismissed their petition. I mean, I understand it's broadly dismissed on the ground that, look, you're a contractual employee. Your contract finishes, you can't say that you have to be continued. Somebody else will come in your place. But having said that, um, the process of renewal is not very transparent. I mean, it's not like we know how many cases X is deciding, how many cases Y is deciding, and on which side they are deciding. But there are people who've spoken about it. It's widely reported, and that's something that's forming the basis on which I could make that comment.
Thank you. Arushi, did you have a follow-up on that?
Yes, Professor. I just wanted to confirm. Okay, I'm again.
Yeah, please go ahead.
I just wanted to confirm whether this is a common trend or not of these specific tribunals having judges appointed and
Oh, sorry.
those
Yes,
contracts being
I
renewed.
forgot to answer. So the other tribunals, see, other tribunals tribunals have a very legislation for that matter, and I can do the exercise till I take the other questions. You will see that when can a tribunal member be removed. So that can only be, and those are the people who enjoy sort of protection under Article 310. They can't be easily removed, and it is a unique tribunal because the appointments here are contractual. So a judge being contractual is something that is new to our system. So you've had situations where judges have passed the retirement stage. The government has not appointed anyone, then the Supreme Court is giving them 3 months, 6 months extension. All right, continue to perform. That's really exercising inherent powers of the court. But a situation where your appointment itself is that, look, you have 1 year or you have 6 months or you have 2 months, 2 years to decide. That's something that is unusual, because once a judge has been recruited, the tenure is protected and you can't be thrown out in the middle. The only exception to it is that if you're on a probation period. So if a magistrate is a fresh graduate, there'll be a probation period of say 1 year, 2 year, depending upon the local rules. And during that period, you can be terminated with a month or 2 months notice, without any further judicial recourse. But once you are confirmed, then it is not easy to remove you. If I want to remove you, you may not be deciding cases, but I will have to show that you're not deciding cases. I will have to point out this case was not decided, why was it not decided, or there are complaints against you by the bar. This is what the bar members are saying. What do you have to say? There has to be a departmental process. So in that sense, this tribunal is unique. I mean, I can give examples of other tribunals where the tenure is protected, but you could also just look it up on how the tribunal members are removed in other situations. And this is a tribunal, and in other legislations, for instance, you will also find strict rules of who can be appointed as a member of the tribunal. And one point that I forgot to mention is that we moved to tribunalization, not to outsource judicial function. That's not the reason why we did tribunalization. We did that to bring in expertise. That is to say that we wanted to have administrative members sitting in the looking after at the employment matters, because they know how the government administration functions, how the employees are to be dealt with. So for example, in the central administrative tribunals, which is what led to the important case of Chandra Kumar, you will find that in the tribunal there is a judicial member and there is an administrative member. You go to any other, you go to competition competition commission, you will find an expert member. You go to electricity tribunal, you will find an expert member. But if you go to foreigners tribunal, who do you find? You find the same person who's sitting in magistrate courts, a fresh law graduate. Or but I mean, the only difference is that in magistrate court, the magistrate is trained. They are recruited by a public exam, then they are trained, then they are seconded to with magistrates, and only after that period is over do they get to preside the court on their own right. But that's not the case that is happening in foreigner tribunal. So you have two members, both of them are lawyers, or maybe one member is lawyer, and most of these people are lawyers. They are lawyers with may or may not be a great practice, because I mean, it is also doubtful, if you have a great practice, why would you agree to be a foreigners tribunal member for 85,000 rupees a month? But some people make great sacrifices, and assuming you have made a great sacrifice, what is the special thing you are contributing? You are sitting there with another fellow member who's also equally qualified as you are. You're not bringing any expertise. I mean, in determination of a foreigner's issue, no special expertise really is required. I mean, you're not bringing any technical knowledge. Reading of documents is not technical knowledge. It is something that the magistrate can do. It is something that the judges routinely do. You bring out documents to show that you have been sitting for 30 years. I mean, the judges are trained to look at those documents, and that's the kind of appreciation of evidence that we are looking at from the members of the tribunal, but we are not getting it.
Arshi, is that all right? Do you have any follow-ups, you or Devanshi? Because we'll just move on to Somejit, and he has his hand up for a while.
No, Professor, thank you so much.
Yeah, thank you.
Yeah, Somejit. Thank you. Yeah, Somejit, please.
Professor, I think Kush had his hand raised.
Kush is an organizer. He can wait. You go ahead.
So,
maybe after
Professor,
Somejit, Kush can
I have this. Should I go ahead?
Yes, please.
Yeah. So thank you for the presentation. And like there was a particular part in your presentation where you talked about the qualification of the candidates who become finally end up becoming the members of the Foreigners Tribunal. So
Yeah.
there's a third point which says that retired civil servants having judicial experience. And in your piece, you actually explained like how the Supreme Court in a particular case called Assam Samhita Mahasangha actually held that how judicial experience actually has to have some connotations to their serving in a judicial office. So, isn't it inconsistent? This particular section, the third section of qualification of a candidate, isn't it inconsistent in its entire meaning if we read along with that particular judgment of the Supreme Court?
Yes, I mean it. I think it was also the judgment of Rajasthan High Court that had been upheld by the Supreme Court also in another context. You see, I have a great problem with two categories, not only with retired civil servant but also with advocates. Now, you may want to argue that advocates, by their very qualification and training, they are suitable to be appointed as members of tribunal. I think, I mean, recently it was also argued in the Supreme Court in the context of the new tribunal rules. By the way, those tribunal rules don't apply here. This is a special tribunal. So, you may want to argue that advocates should also be eligible to be members of the tribunal, but I mean, I would say yes, but train them. So I'm not saying keep people out. I'm saying have lawyers, have civil servants, but train them. So you see, merely having judicial experience or being an advocate is not enough. And judicial experience, when you say bureaucrat, it doesn't say the duration or the length or time did you have the judicial experience. So you are correct that, you know, merely mentioning judicial experience is not enough. It has to mean something more. There has to be a quality that is to be attached. Now, especially given that this is probably the only tribunal that may have the power of detention, because, you know, you're arrested, you're brought, and then, you know, you go to the foreigners tribunal. Eventually, you know, if you're not able to prove, you go live your life in detention center. And in that sense, this is not a power that any other quasi judicial body or a tribunal will have. So, I mean, in my understanding, probably this is the only tribunal that has such drastic powers. So all the more reason to have it exercised by people who are trained and who are more likely to apply it most carefully and independently.
Kush?
I had another question. It's a very short question. Can I go ahead?
Yeah,
Sure,
please,
sure.
please. That's not very polite. Samijit, we are waiting for your question.
So my question is basically, in the beginning, you actually stated that the rule of law has different dimensions, and in the positivist interpretation, you gave a lot of inference on Joseph Raz's theory of, you know, how independence should be attached. So even if we look at it from an administrative law perspective, and the very nature of this foreigners tribunals, especially being quasi-judicial in nature, the independence aspect of the entire tribunal system, isn't it very questionable when there is no guarantee of this period that is being given to them? Like it's always pursuant to certain, like the number of decisions that you give and like on which end you end up giving your decision.
So, I mean, we will have to make a distinction between uh, renewal of their contract for employment, which is their decisional autonomy. It affects their institution decisional personal decisional autonomy. The second part is the institutional part of it. So the institutional part of it, of course, I mean, you see that's something that must be there. But as a person also, you have to view it in individual level. So I would go a step further and would also say that when viewing independence of a person, you have to view it independence of one person, one judge from the other. That he should, if he or she wants to take a dissenting view, he should be absolutely uninhibited. That, you know, the person sitting next to me is a senior person, that I should simply follow him. No. if so, those are, I mean, it has to go as far as that. So I mean, you're right that there are concerns about the future because of the way in which the contract system is working, or the renewal of contract is working. But that's only just one indicator. There are various other indicators. I mean, uh, one could look at the kind of, the expectation from you, not simply to say that I will renew your contract, but also to, to be to be understood as somebody who's deciding in, say, and releasing a lot of people, that they are actually citizens, they are technical foreigners. And a large number of this could be an unsaid criteria, because you see, there is absolutely no transparency. You're not allowing people to go inside the so-called courtroom. People are not able to hear what's going on. There are also people complaining that, the prosecutor is not saying anything, the judge is also assuming the role of a prosecutor. Now, this is some, and also you see, it comes in a backdrop of where the reference is made by the state agency, and the state agency is also then pursuing it. And if they don't like it, they're also recommending an appeal against it, or not really appeal, but, a writ against the order passed by the Foreigners Tribunal. And if the appeal is not filed, the High Court says, all right, why have you not filed the appeal? I mean, that's the kind of expectation. The High Court will not say, oh, go file an appeal. It will simply ask you that, if those people, hundreds of people have been declared as citizens, or not foreigners, then why don't you appeal? Why has appeal not been filed? So, that's a soft question put by the review person, and that review person, the person who's making that the request, will have to then understand, take a hint from there, that I'm expected to file an appeal from a writ from this. So there are various factors, and if we if we have access to the decision making process, the data, the stats, that will show a different picture.
Yeah, Kush, please go ahead.
Professor, I think it's actually been some time since we've had your questions. So I think by virtue of your seniority and by virtue of the nature of my intervention being just limited comments, I think we should have your questions first.
No, go ahead. Please go ahead. We can
Okay.
take 5 more minutes, and if there's time, I'll just ask Talha. But Talha and I speak more regularly than I'm assuming Kush and Talha do. So it's fine.
That is true. First of all, sir, thank you so much for taking your time. This was a wonderful presentation and an even more wonderful piece to read. I just had brief comments about some of the aspects that you mentioned in your presentation. The first of them having to deal with how the Foreigners Tribunal is very haphazard in terms of applying the rules that it's supposed to be bound by, which could be prescribed by statute. And this is particularly in the context of ex parte proceedings. And from what I've researched, I've seen there's been a slew of Guwahati High Court orders that basically sort of made the same observation, that the foreigners tribunals were acting in a mechanical manner in terms of serving the notice. And the homestead where the person accused was previously staying was no longer there, and they did not follow the requirement of affixing the notice at some conspicuous location. And it was just the proceedings carried on in a very haphazard manner. So in terms of ex parte proceedings, a lot of the basic requirements that afford the other party to sort of respond to the claims that are made are definitely missing. I really did like the jurisprudential invocation of Raz, and particularly how the Foreigners Tribunal can be argued to be very antithetical to the idea of the service conception, in the sense that it, by virtue of its setup, it's not really serving the people who are adversely impacted by it. And of course, we cannot sort of view this in some sort of a vacuum, because from what I understand, the service conception argument is sort of is double-ended, in the sense that both sides could perhaps argue it in a given way, particularly in the concept of the legitimate authority. But given the sort of consequences that the proceedings of the foreigners tribunals entail, I really don't think that it is an argument that can be sort of proceeded without bearing the consequences in mind. One question that I wanted to sort of put forward was, in the context of international law, and how or whether there are arguments relating to international law advanced at litigation at the Supreme Court or the High Courts, and what is the general response of judges in terms of considering these arguments? Because from my understanding, in some instances, international law is viewed as consistent with state practice, but particularly in this regard, I think there's a reasonable suspicion and fear that international law may perhaps not be seen as in line with what the state wants. So if I could have your comments on that, sir. Thank you.
So I would say when it comes to arguing or applying international law in the Supreme Court, a lot depends on what in international law do you want to apply or do you want to argue about. So I mean, for example, ICCPR or UDHR, these are all conventions that have been routinely applied, and there are many judgments which apply. In fact, if I remember correctly, there's a paragraph in even in Keshavananda Bharati which refers to Universal Declaration of Human Rights to refer to the basic nature of certain rights that are guaranteed in that declaration. So it really depends on what kind of international law you are arguing. So if you try to argue about an obligation for which there will maybe a requirement for having an enabling legislation for it, then it is slightly more difficult to argue. But I mean, I'm not saying it's impossible, because you see the way courts have interpreted it is that if it is not if there is an obligation created by international law, but it is not contrary to any of the domestic law, and then the courts will actually be willing to apply. And if, I mean, there was a recent judgment of the Supreme Court in the context of anti-dumping duty, Justice Nariman's judgment, where he's developed some 7-8 principles, I think, and this is one of those principles that when it comes to interpretation of rights, nature of rights that India guarantees or in Indian statute provides, it is always open to have reference to international law if it creates an obligation for India and there is nothing inconsistent in Indian law. So when I would view this in the context of statelessness, well, you can say that there may not be a positive obligation on India to take steps to reduce statelessness, but you can definitely argue that there is an obligation on India to ensure that the law that it applies for any person is consistent with ICCPR and consistent with basic declarations under the UDHR. So at least that bit you can argue. But whether or not refugee convention apply, whether or not things like that, there are, I mean, obviously you will have to then make a distinction on something that applies irrespective of the the treaty being acceded to and not.
Great, thank you so much. We have just run out of time, so I think in the interests of everybody, especially Talha, because I'm sure we don't want to exceed our welcome with his busy schedule. So I'll just bring the session to a close. Talha, we collectively on behalf of everybody really want to thank you. This has been an exceptional session. I'm sure everybody agrees. And a few things which are striking is the extent to which you were able to cover a really complex area of legal practice, a practice which is quite ad hoc and quite erratic, and to be able to both interpret it and present it in both a coherent frame and offer a very strong and sharp normative critique is only something which I would have expected you to be able to do so well. Very few other people can do it. And it was a great learning experience. It is particularly useful for us because over the next many weeks, we'll continue to have a conversation about citizenship determination processes. We're interested in looking at what other countries are doing, what international, I think maybe Kush was sort of gesturing towards that. We're interested in looking at how international law is able to contribute to it. So I'm hoping that we collectively, as part of the clinic, would continue to communicate with you. And we'll be very interested to know how sort of the resources we are able to generate from inside the clinic are useful for you and other colleagues in the court to pursue for in the interests of justice, as they say. So thank you so much, Talha. Hope to see you very soon, and thanks to everybody else for their questions and comments.
Thank you, Mohsin. Thank you, Ashish. Thank you, Push.
Thank
Thank you to
you.
all the students.